A deposition is a sworn statement given by a party or witness before trial during the discovery process. Basically, in order for all the known facts and witnesses to be heard prior to trial, all courts engage in discovery. The goal is to allow everyone involved to see exactly where everything related to the case stands, so they might settle the case, as opposed to tying up the court system with litigation. For those cases where the parties do not wish to settle, then they can proceed to trial without the risk of last-minute surprises. The basic idea of the system is to have everyone lay all of their cards on the table to be seen by all and get to a fair resolution of the dispute. Our nation guarantees that every person shall have his day in court and that for every wrong there is a right. A deposition is controlled by rules of court. In a deposition, the lawyer for every party is present with whoever is going to be testifying. For example, in a medical malpractice suit, the defense lawyer is going to want to take the depositions of the plaintiff victim, of any witnesses for the plaintiff, as well as the plaintiff's expert medical witness. The defendant, usually represented by a lawyer from an insurance company covering the doctor, will always want to know what everyone is saying happened. He will certainly want to know what the expert medical witness will say about the injuries to the plaintiff. The plaintiff's lawyer will want to know the same things about the defendant's case. The deposition, sometimes called a discovery deposition, is conducted then for each party to learn the facts about the other party's case. It is not the time for cross-examination, which is neither proper under the rules of court nor advisable anyhow. That is saved for trial. The deposition is usually taken at a lawyer's office. There will be a court reporter present who is taking everything down word for word. The lawyer will prepare the witness in the process, but here we can generally tell you that you should take this procedure very seriously, as what you say here can be used against you in a court at trial. If you make smart remarks or fail to tell the truth, the odds are you're going to regret it. In general, your best approach is to be neat, clean, respectful, honest, and prepared. Moreover, the other lawyer is always sizing you up to see how you'll perform at trial before a jury. There simply is no substitute to a good performance, which includes being thoroughly rehearsed and prepared by reading and being very familiar with all of the medical and other material. When you are the person being deposed, you should answer the question honestly but avoid long-winded narrations. When an excited plaintiff talks too much, mistakes start to occur, and then you're assisting the other side. In short, make sure you listen to the question and only answer what has been asked. If the question calls for a yes-no answer, then give it and stop talking. It is not your job to fill time or keep talking. In short, if there is silence, then let there be silence. In most court systems, there is a time limit on depositions, so if the opposing lawyer wants to waste time, then you should not interfere with that. There is always a tendency for a witness to try and fudge an answer in an attempt to make the case stronger, but you should avoid this. It doesn't usually help the case as much as you think it would anyhow, but even worse is if the opposing lawyer is setting you up to see if you'll lie. Once a person falls into that trap, then the lawyer will show the jury how dishonest you are at trial, hoping then that they'll reject your whole case and find the defendant not liable. Surprisingly, there are a few lawyers who can act like ignorant idiots at a deposition. Such lawyers are a stain on the system. They may try to push a witness around, raise their voice improperly, or fail to follow the rules in general. Your lawyer should deal with this, but where you have no lawyer, you can yourself. The idea of being in court doesn't include people losing all of their rights that they ordinarily have out of court. If a lawyer gets out of line as a person, then you can warn that lawyer politely but firmly. If the warning doesn't work, you can always walk out of the deposition and let the judge know what's going on when you get back to court. They say the loudest one in the room is the weakest one in the room, and this is especially true for some lawyers. The rules are very clear in every court system that people are to act with civility and respect the other people present. Any lawyer who gets out of line is not acting within the guidelines of the law, but as an ignoramus. This is truly a sign of the lawyer's incompetence, both as a lawyer and as a person, and should never be allowed. Do not be afraid that the judge will blame you. Bad lawyers bank on you being afraid since you're unfamiliar with the legal system, but the truth is that you have the right to be treated with dignity, even if the lawyer doesn't like your testimony because it may be helping your case. The court reporter's transcript will show the judge exactly what the lawyer was saying when the trouble erupted, and so the lawyer won't be able to lie in court. But you do have to know that you have to call the court reporter's office and ask for the transcript for that deposition to be prepared and sent to you, as they ordinarily would not do that unless paid to. A good lawyer will always properly prepare you for your deposition. The lawyer should tell you how to dress and speak. In general, you should answer the questions honestly and to the point. Rambling on a long narration is unwise and can hurt you, as you may say something inadvertently that wasn't asked or that can be taken the wrong way. Answer the question and only the question, and then be quiet. Do not be embarrassed if no one is talking. Just wait for the next question and remain quiet. Always wait a brief second before answering a question to allow time for your lawyer to object if needed. If your lawyer objects, you should immediately stop talking and let the objection be made. Your lawyer will advise from there. Understand that since there is no judge present, the vast majority of objections cannot be ruled on right away, and so you are then allowed to answer the question with the objection noted. The court can rule on the objection later and either order the question stricken or left intact. Finally, be aware that defense firms commonly have the defendant doctor at the deposition to listen to the evidence and to sometimes try and intimidate you. The doctor may not speak in the deposition, but can consult privately with the lawyer to assist in defense. Plaintiffs rarely have a doctor there for them to counter this. MedWitness Limited actually does provide professionally trained doctors to attend such depositions and counter the defendant's doctor. This allows your lawyer to have the benefit of up-to-the-minute medical assistance as needed, just like your opponent.